Greetings, everyone. I'm Patricia Lee, Chair of the American Bar Association Standing Committee on Public Education. I'm pleased to welcome you to today's program, a civil debate on the topic of Supreme Court reform, the first in what is planned to be a bi-monthly series of civil debates on critical and often contentious legal issues. I want to thank the partners who have planned this program, including the Chicago chapter of the American Constitution Society, especially David Melton, the Chicago chapter of the Federalist Society, especially David Applegate, and Reform for Illinois, in particular, Alisa Kaplan. I also want to thank today's speakers, Erwin Chemerinsky, Dean of the University of California, Berkeley Law School, President of the American Association of American Law Schools, and renowned constitutional law scholar. John Hsu, Federalist Society contributor, professor, attorney, and legal commentator focusing on areas including constitutional law, securities and corporate law, politics, and international affairs. And Alisa Kaplan, Executive Director of Reform for Illinois, who will serve as today's moderator. Now I turn the program over to Alisa to introduce and begin the debate. Thank you all for attending.
Alisa, you're on mute.
That's embarrassing. Thank you, Patricia. My name is Alisa Kaplan, and I'm the Executive Director of Reform for Illinois. Reform for Illinois was founded in 1997 by a Democrat, Senator Paul Simon, and a Republican, Lieutenant Governor Bob Kustra. We're a nonpartisan organization that advocates for policies that create a more ethical, accountable, and inclusive democracy. I'm so excited about this discussion, which could not be more important or more timely. And I'm so thankful to our guests for taking the time out of their busy schedules to be with us. The format of this program will be a formal debate followed by a discussion with audience questions. We'll take audience questions via the Q&A feature you can see at the bottom of your screen. The program offers continuing legal education or CLE credit to Illinois attorneys, and we'll have some more details about that at the end of the program and at this link in the chat. The resolution we are debating is resolved that Congress should establish non-renewable 18-year term limits for United States Supreme Court justices. Each participant will have 13 minutes to make their argument and then 2 minutes for rebuttal. After that, as I mentioned, we'll extend the discussion with additional questions. There'll be a timer on the screen, and I will give you 3-minute and 1-minute warnings. It's now my honor to introduce Professor Chemerinsky, and who will be arguing for the resolution, and legal commentator John Hsu, who will be arguing against. Professor Chemerinsky, since you're arguing in favor of the resolution, you go first.
Thank you so much. I'm honored to be part of this discussion. No other country in the world has life tenure for its judges. Among the 50 states, only one has life tenure for its judges. I support the idea of 18-year non-renewable terms for Supreme Court justices. Let me give you 3 reasons why I support this. First, life tenure means there's too much power in a single person's hands for too long a period of time. Thankfully, life expectancy is a lot longer today than it was when the Constitution was written in 1787. Then average life expectancy was 36 years old. Today, of course, it's more than double that. If you look at the average tenure of a Supreme Court justice through even the 1970s, it was 15 years per justice. Now for the justices who recently left the court, the average tenure is 28 years on the court. Or to put this in terms of individuals, Clarence Thomas was 43 years old when he was confirmed in 1991. If he remains on the court until he's 90 years old, the age was just as John Paul Stevens retired, Justice Thomas will be on the bench for 47 years. This isn't partisan. Elena Kagan was 50 when she was confirmed for the Supreme Court. If she stays until she's 90, she'll be a justice for 40 years. Amy Coney Barrett was 48 years old when she was confirmed on October 26, 2020. If she stays on the court until she's 87, the age was Justice Ginsburg died, Barrett will be a justice into the year 2059. Simply to have a person on the court for 47 or 40 years is just too much power in one person's hands. It risks having justices who are out of touch with the needs of society. When you have somebody confirmed in 1991 for remaining on the court for 47 years, hard to believe that they will still have the perspective and the understanding that we want on the Supreme Court. Also, we have to recognize the problem of diminished capacity with age. The idea of having justices regular in their 80s and their 90s, maybe they can do it, maybe they can't. We don't have another mechanism to deal with it. I think the idea of 18-year non-renewable terms would achieve that goal. But I'd offer a second separate argument in favor of this. 18-year non-renewable terms gives every president an equal chance to appoint justices. Too much now depends on the accident of history as to when there's vacancies. Look at the current court. Between 1960 and 2020, we had 32 years with a Republican president and 28 years with a Democratic president. In fact, in 2024, it's going to be even, 32 years with a Republican president and 32 years with a Democratic president. But between 1960 and 2020, Republican presidents picked 15 justices, whereas Democratic presidents picked only 8 justices. There's no justification for that kind of disparity. It's largely a reflection of just the accident of history when vacancies occur. President Richard Nixon got to fill 4 vacancies in his first 2 years in office, but President Jimmy Carter got to fill no vacancies in his 4 years as president. Or I can put this another way. President Donald Trump got to fill 3 vacancies in his 4 years in the White House. But the prior 3 Democratic presidents, Jimmy Carter, Bill Clinton, and Barack Obama, served a combined 20 years in the White House. In those 20 years, they were able to pick only 4 justices for the Supreme Court. We shouldn't have the composition of the Supreme Court determined by the accident of history. Elections matter. An election should determine who gets to fill vacancies. 18-year non-renewable terms, if it's implemented in a staggered way, would mean 1 vacancy every 2 years. 18 is divisible by 9. So every president would get to fill 2 vacancies on the court. Every election would have equal consequences with regard to this. I worry also, if we don't do this, we're in a situation where justices can, in essence, determine the political ideology of their successor and continue a seat being in those hands for years to come. Stephen Breyer stepped down so that a Democrat could replace him. I worry that if a Republican is elected in 2024, who's a Republican Senate, then Clarence Thomas might step down or Samuel Alito step down to be replaced by conservatives who are in their late 40s or early 50s, keeping conservative control for a long time to come. We shouldn't have the Supreme Court as an independent, self-perpetuating board. Vacancies at regular staggered terms would avoid that. Third, I would argue that 18-year non-renewal terms strike the right balance for the desire for judicial independence and the desire for judicial accountability. That's ultimately our goal when it comes to the method of selecting justices and the method of determining when they leave office. How do we assure their independence, but also preserve their accountability? I think that having 18-year non-renewal terms certainly gives them independence. It also provides a sufficiently long period of time for them to have the learning curve to be able to master the job and have an influence. On the other hand, there's also accountability. As I said earlier, I think the idea of a justice serving 40 or 47 years undermines the accountability of the system. And so I would argue here that 18-year non-renewable terms is the way in which we should strike the right balance. What I'm encouraged by is that I think that this is politically realistic. I have heard conservatives support 18-year non-renewable terms. So the Texas governor, Perry, who ran for president of the United States, argued in seeking the Republican nomination for 18-year non-renewable terms. And obviously liberals support this as well. This most easily could be accomplished through a constitutional amendment, but I also believe it could be done by legislation. And this goes to the part of the resolution in terms of Congress. There is nothing in the Constitution that says that a Supreme Court justice needs to have the position on the Supreme Court for life. It says, once confirmed, the person is a federal judge for life. So Congress could say after 18 years, a Supreme Court justice shifts to other responsibilities in the federal judiciary, serving on the Supreme Court if a justice is recused, serving as a Court of Appeal justice, as some do. And in this way, we can accomplish the goal, not by constitutional amendment, by congressional legislation. I think we are at a crucial point in American history with regard to the legitimacy of the Supreme Court. Last fall, a Gallup poll showed the Supreme Court had its lowest approval ratings in American history, 40% approval, 53% disapproval. A Gallup poll in mid-June showed that only 25% of the American people expressed confidence in the Supreme Court. This was even before the decisions at the end of June that were quite unpopular. More recent polls show, such as one that was reported by Marcia Coyle in the National Law Journal, that the Supreme Court's approval rating now is below 40%. I believe we're at an inflection point with regard to the Supreme Court and democracy where action needs to be taken. Reform with regard to the Supreme Court is essential. 18-year non-renewable terms, I think, the way to do it.
Thank you, Professor Chemerinsky. Can we reset the timer?
Yeah, the timer is reset.
Okay, John, go ahead.
Sorry. Thank you to the American Bar Association, and please give me a moment. Sorry, it's tough to be popular. So thanks again to the American Bar Association. Thanks to the staff, Frank and Tiffany. And thanks to my fellow Californians, Pat and Erwin, and of course to our excellent moderator, Alisa. Thank you very much. It's a great pleasure to be here. I think the overarching theme that one should consider is, if it ain't broke, perhaps we shouldn't fix it. Oftentimes, when it comes to the Constitution, in the past, when we've tried to fix things, it hasn't turned out all that great. Sometimes it has, but sometimes it hasn't. When it has worked out well, it's because there was some clear flaw in the Constitution. In this case, it's not clear to me that there is. I think even proponents of the 18-year fixed term, like Erwin and others, would agree that judicial independence is a very important thing and the cornerstone, at least one of the cornerstones of our judicial system. With respect to comparing our federal system with state systems or with international systems, I think we're rightly proud as Americans that our federal judiciary and federal judicial system is unique. And I think that the fact that our system works so well compared to others, and that we have a great rule of law, I think that's something that we should treasure, not something that we should hand away. With respect to the states, state court judges handle different things than federal judges. They develop the common law. There's some discussion of policy sometimes. And so for them to be elected or have fixed terms, or in some states, age limits, I think that's fine. But again, for the federal system, it's not clear to me that the term limits, or other people have suggested a maximum age. It's not clear to me that that fixes anything at all. And it seems to me that what proponents of the fixed term would like to fix, it's really a political problem, not a judicial or a legal problem. And for example, I don't remember hearing anybody from the left complaining that Billy Brennan or Thurgood Marshall or Earl Warren or William Douglas were in the court too long. Maybe we should have, shorter terms, whether it's 5 or 7 or 18 or 9. And by the way, I think the fact that you say, well, 18 years is divisible evenly by 9, to me, it doesn't make any difference. Why not have a 9-year term? Well, because that's not long enough for a judge to get his groove on. All right, well then how about a 21-year term? Because that's 2 1/3. I mean, it's, 2 years and 4 months. To me, it doesn't make any difference what the number is. The idea is unsound. It's so far unconstitutional. And the other thing is, I've seen some of the proposals, that one of the first proposals that I remember seeing in a law review was from Philip Oliver, all the way back in 1986. But even before then, we've had congressmen in the 1800s pitch for changes. Sam Nunn in the 70s, Sam Nunn for the younger people in the group, he was a Democrat senator from Georgia for many years. Sam Nunn in the 70s pushed hard for changing the terms for Supreme Court from good behavior to a fixed year. So it's really not anything new. I think it's because of the politics. I've never seen anybody from the left say, well, if we have magically 9 people who vote like Billy Brennan, we should have fixed year terms. And from the right, if we have 9 people who are like Clarence Thomas, we should have fixed year terms. To me, that's not a problem that's for the constitutional amendment to solve. If you don't like the way Supreme Court justice votes, then the solution is elect a different president, elect different senators. It's not to mess with the Constitution when you don't need to. I think another problem that you have is the implementation of it. What do you do? There's an old joke that amateurs discuss tactics and professionals discuss logistics. What do you do? Do you apply the 18-year terms to the sitting justices? I think that would be a huge problem. If you say, no, we'll just apply it to justices who come on board new. All right, well, some studies have shown that it would take about 48 to 52 years for all the justices to be now on staggered terms. Because even if you do it gradually, to put the justices on staggered terms, it's going to take a while to get to that magical 2 every presidential term. The fact that Republican presidents have had more Supreme Court justice appointments recently, when I say recently, I mean over the past 50 years, over Democrats, I don't, that's just an accident of history. That wasn't intentional. If the Democrats had won more elections, maybe it would have worked out better for them. And the fact of the matter is, and I'm being semi-facetious, but the Republican presidents haven't been all that great in selecting conservative justices. I mean, Harry Blackmun, Lewis Powell for Nixon, David Souter for HW, whom I love and adore, work for. 43 almost appointed Harriet Miers, or he did nominate her. And then, of course, there's some question as to whether the Chief Justice is actually a conservative or an originalist. And even those that are, I would note, Neil Gorsuch wrote the Bostock opinion. That was pretty recently. And I would imagine that those on the left would be very pleased with Justice Gorsuch's opinion. Certainly Justices Sotomayor and Kagan and Breyer were, because they joined it. So again, I don't think it's smart to completely change the Constitution because you don't like a political result, or you don't like a case result, or a series of case results. It's not a good idea. The other thing about the Supreme Court being counter-majoritarian, Well, it's supposed to be counter-majoritarian. It's designed to be counter-majoritarian. And not just the Supreme Court, but the entirety of the federal judicial system is supposed to be counter-majoritarian. It's counter-majoritarian to release a guy that you know is guilty because the police broke the violated the Constitution and abused his civil rights. A lot of people don't like that. They figure if he's guilty, he's guilty. Well, that's why we give them a job during good behavior or lifetime tenure, because that's what they're supposed to do. Now, I understand, the counter response, of course, is that, well, but they have 18 years to do it. Yeah, all right. But I mean, it's not the same. It isn't the same. And for example, just as an analogy, not a perfect analogy, but a close analogy, professors who have lifetime tenure, or maybe not lifetime tenure, but who have tenure. Let's say a guy starts teaching at DePaul University Law School in 1980. Now it's 2022. Should we consider him decrepit? Should we force him out? Should we say the tenure has a limit? I don't think so. Not automatically. Not if he's clearly smart. He's clearly has all his faculties. He's clearly publishing and teaching and being active. I feel very uncomfortable with that. I feel very uncomfortable with the same application to judges. The other question I have is, in some of the proposals I've seen, they want to apply the fixed terms to the entire federal judiciary. Some want to apply it only to the Supreme Court. I believe either way, not a good idea. And the logistics that I mentioned before, it would be even harder if it was for the entire federal judiciary. Now, the Constitution itself, the original text, does distinguish between judges of the Supreme Court and other officers of the United States. The inferior court judges are considered other officers. So there is some opening to treat the Supreme Court justices differently, and we certainly give them original jurisdiction over certain things. So to that extent, that's understandable. But at the same time, that also means that it isn't right to force a guy off and then send him to pasture, whether it's to then sit in for a recusal or to sit in on an inferior court, even though other justices have done it. I know Justice O'Connor did it and other justices have done it, but that's a little different because they're stepping down voluntarily, retiring or taking senior status voluntarily. The other problem is what happens during the 2 years when a Supreme Court justice dies. Now, Erwin mentioned a recusal, but what if he dies? Or what if he just ups and decides to quit? There's no requirement that he has to stay the full 18, and that may not even be possible. I think, what do you do then? Well, I think a lot of the proponents would say, well, bring on one of the justices that's been forced out after the 18-year term, and that person can sit in. But can he though? Because does he need to be reconfirmed? You can just stick him back on the bench. I don't know that those questions have been adequately examined and answered. And then last but not least, with respect to public polling of the Supreme Court, again, we give lifetime tenure so the Supreme Court doesn't care about public polling, or Supreme Court justices don't care. Now, they shouldn't care, but you know that they do in your heart. And there's the infamous, quote, greenhouse effect, which is named after Linda Greenhouse. But I think the real problem is with the left. A recent poll showed that 72% of Republicans have a very good impression of the Supreme Court, but 53% of Democrats would, quote, abolish the current Supreme Court and replace it with the, quote, new democratically elected Supreme Court. 64% of Democrats favor expanding the Supreme Court to 13 justices. 56% of the Supreme Court, or 56% of Democrats believe the Supreme Court is racist, and 67% believe it to be sexist. When President Trump was in office, I think people rightly criticized him when he would, just namby-pamby criticize the Supreme Court for a ruling. But when President Biden does it, or when President Obama did it, for example, for Citizens United, regardless of whether you agree with it or not, that seems to be okay. And I think that's a real problem for viewers of the three major networks or MSNBC. So again, I think that it's an interesting idea. It's great for academics, but it's not good for the country. It's not good for the court system, and it certainly wouldn't do anything to fix the problems. Whether you're talking about looking at the way that Supreme Court justices decide cases, or whether you're talking about the nasty confirmation process that we've turned into now. If you think confirmation process is nasty, just wait till you have to do it every 2 years. Thanks very much.
Thank you, John. Now we'll have 2 minutes for rebuttal on each side.
Ready to start? Are we ready?
Yeah,
Oh, okay, I'm sorry.
that's okay.
John says it isn't broken. I give you 3 reasons why it is broken. That justices are serving for far too long a period of time, that too much depends on the accident history. We don't have the right balance between accountability and independence. He says this is all political. Not a word I said had anything to do with politics or ideology of the justices. The reality is, whether it's Democratic appointed or Republican appointed justices, these arguments apply just as much. Go to my 3 points. First, life tenure means there's too much power in a person's hands for too long a period of time. The idea of a justice serving for 40 or 47 years in that role isn't desirable. It isn't desirable because they're likely to be out of touch with society. It isn't desirable because they're likely to be in a situation where some of the time they're no longer able to do the job. 18-year terms give them the chance to develop the expertise without having so much power for such a long period of time. Second, I argue that 18-year non-renewable terms will give every president equal chance to appoint justices, and that's desirable. John says, well, the solution is Democrats should win more elections. And if the Democrats won, that would be happen. He ignores the statistics. Between 1960 and 2020, Republicans won 32 years and Democrats won 28 years. But Republicans got to pick 15 justices and Democrats got to pick only 8 justices. The composition of the Supreme Court should not depend on the accident of history. Of course, not only the accident of history, we also adhere to the manipulation of the process and Senate Majority Leader Mitch McConnell blocking Merrick Garland from being considered. Every president should have an equal opportunity to pick Supreme Court justices. Finally, I say that 18-year non-renewable terms strike an ideal balance. He says there's implementation problems. We could easily implement this in a staggered way. We could, with 18-year terms, have each president picking every 2 years. There's no problem in developing a system to make this work.
Thank you, Professor.
Okay, and we are reset for Professor Hsu. So whenever you're ready.
Oh, thank you, Tiffany. And thanks again to Dean Chemerinsky out there in the Bay Area. I think, again, it is political, not necessarily Democrat, Republican, that simple, but political with respect to the fact that, certain people don't like the way that this court currently stated. And by the way, it's not 6-3 conservative. I'm sorry, it's just not the case. But at any rate, that this court is that they don't like the rulings. All right, well, I mean, there's been plenty of history where the people on the right didn't like the rulings either. Now I know Erwin would say, but people on the right wanted it too, the 18-year fixed term, and I would agree. That's right. I mean, Steve Calabresi published a paper back in 2006, and so Erwin's right on that. But again, he doesn't. Any of the people who support a fixed term do not show the absolute clear flaw that requires a constitutional amendment, or even if they think it can be done by statute, which I don't think it can. That we should take that route to amend the Constitution in this way. Some of the proposals I've seen, I mean, it looks like the Fair Labor Standards Act by the time it's written. It's so complicated. That's not how a constitutional amendment should be written. I'm sorry, that's not what the Constitution is for. Constitution is not a procedural manner in that sense. And then, with respect to the fact of age or being on the court for a long time, again, nobody complained when Bill Douglas was on for a while. Billy Brennan. Thurgood Marshall was on until he was like 90. John Paul Stevens was on until he was 90. He was a Nixon, or he was a Ford appointee. Nobody complained about that. So at any rate, but thanks again to the ABA and to all the folks who are listening in. I appreciate it.
Thank you. Okay, thanks for your comments. Now we'll move into the Q&A section of the program. We have 2 questions that have come in so far that I think really hit on an important point with this issue, which are what problems this proposal would solve and what problems it would not solve, and perhaps what other reforms would have to go along with it in order for it to be effective. So one attendee asks, how would your proposal, Dean Chemerinsky, account for instances like the nomination of Merrick Garland when the Senate controlled by the president's opposing party blocks a vote until another president takes office?
The Constitution assumes the good faith of those who act under it. And so the Constitution has always assumed that if the president nominates, the Senate will take action. And that was true throughout American history until 2016, when Senate Majority Leader Mitch McConnell and the Republicans acted in bad faith and blocked the consideration of Merrick Garland. And the reality is, if the Senate's going to do that when they're on the opposite side, political party is the president, then we're not going to get justice confirmed when the president and the Senate are of different political parties. And our current system isn't going to work, and this system isn't going to work. If I were to design a constitutional amendment for term limits, I would create an obligation for the Senate to vote up or down. And if it doesn't, then there could be the equivalent of a recess appointment.
I would say that we don't need an equivalent of a recess appointment because we have a recess appointment now. And by the way, only the Senate gets to decide whether it is in recess or not. All of you have probably seen where there's the Senate says that it's still conducting business in session, even though they're not really doing very much, but reading the telephone book. But that's because that's what they get to do. By the way, I think it'd be very hard to get a statute or especially a constitutional amendment through where one house, the House, would be telling the Senate that they have to act on something within 120 days or whatever the time period that the proponents would like to see. So that's a big problem. I think with respect to Judge Garland, or now General Garland, I met him when he was a judge, so I still think of him as a judge and chief judge in DC. But first of all, I would correct Erwin a little bit. In the 1800s, I think 1860 something, we had a situation where the Senate would not consider a presidential nominee for the other side. It is true, but since that time until now, we haven't had any. And as a matter of fact, in 1992, then Senator Joseph Robinette Biden went on the Senate floor and publicly stated and sent a clear message to President George H.W. Bush that this was about less than a year after Justice Thomas was confirmed, that if President Bush 41 had another vacancy, that the Senate, and certainly not Chairman Biden, would consider it, would even have hearings on it, et cetera, et cetera, et cetera. And that's why Mitch McConnell, who I understand is hated by the left, that's okay, he actually rebels in that. But that's why McConnell always referred to it as the Biden rule. And I'm sympathetic. I don't 100% agree, but I am sympathetic to Leader McConnell's statement that putting Judge Garland through hearings only so that he could be voted down, that's a pretty grievous process. And if it wasn't necessary to do it, I actually think he did Judge Garland a favor.
Professor Chemerinsky, do you have a response to that before we move on?
No. The Democrats didn't keep a nominee from being considered in the way that the Republicans did in 2016. It never happened. And in fact, what Mitch McConnell said in 2016 was that a president shouldn't be able to pick a justice in his last year in office because the people should get to decide. That's very close to a verbatim quote. But of course, when Ruth Bader Ginsburg died on September 21st of 2020, Mitch McConnell rushed through Amy Coney Barrett to be confirmed on October 26th. That is the most blatant hypocrisy I have ever seen. The reality is the way in which the Republicans were able to get that seat on the Supreme Court was manipulating the process. And that's what I object to.
And again,
Okay.
I wait, just really quickly, I would say that Erwin admitted it wasn't a verbatim quote. And the reason is because what Mitch McConnell actually said was that with respect to Judge Garland was when the president and the Senate are held by different parties. That was not the situation when Justice Ginsburg passed away. The Senate and the presidency were held by the same party. So that's why it's different. That's why it was done the way it was. And I personally was very sad to see Justice Ginsburg pass away.
Okay. Okay. I want to make sure that we keep to the topic here and not debate the many grievances between the two parties. So I want to come back to this particular proposal. The other reform that could conceivably be impacted by this proposal is the filibuster. So the filibuster has been eliminated for Supreme Court nominations. Would either of you see bringing back the filibuster as something that should go along with this reform that could be a benefit to it or enhance its performance? Or should we keep things the way it is? Would it solve the problem of finding consensus? Would it help find consensus in the Senate, or is that just long gone?
I would eliminate the filibuster entirely. I think the filibuster is actually unconstitutional. It's certainly undemocratic. Senators representing a small part of the population shouldn't be able to keep the majority from doing its business.
John?
I think with respect to the filibuster on Supreme, I'm going to divide this answer into three parts, because when you talk about filibuster, you have to be specific about what part of the filibuster. Although Erwin was specific that he said he'd just get rid of it totally, and at least that's a defensible position. So thank you for that. First, I would note for the record that it was when Harry Reid was the majority leader that he got rid of the filibuster for Supreme Court justices. That's just start with that. Number two, with respect to filibustering Supreme Court justices or appellate court justices, I would leave that up to the Senate. That's their rules. They get to decide. I personally feel uncomfortable with it. I personally feel like the Senate, if they're going to take on any kind of hearing, whether it's for a cabinet officer, an ambassador, or a judge, take it up, vote him in or out. That's what should be done. But if they want to filibuster it or blue slip it, I would presume maybe that Erwin would want to get rid of the blue slip process too, because that's kind of undemocratic. With respect to the fact that it's considered by some to be undemocratic, well, or that certain senators from low population states like Wyoming compared to high population states like California. First, if you're going to make that argument, then you're not only going to get rid of the filibuster, you got to get rid of the entire electoral college. And second, our whole system is based on the fact that states have representation too. And so, yes, the upper house has 2 senators from each state, and the lower house is done by population. That's the way it is. It's been a great system so far. It's perfect. I'm not saying it's perfect. We're not perfect. So that's what I would respond to that.
Okay, I want to ask again that the participants stick to discussing the questions in the context of this proposal and not get sidetracked just because of limited time. So let's stick to the impact. I know there's tons to unpack with the filibuster, but let's stick to the impact of on this proposal. Professor Chemerinsky, you were shaking your head at one point about the Supreme Court nominations.
Well, first, I want to correct the facts. The Democrats, when Harry Reid was majority leader, eliminated the filibuster for federal district court, federal court of appeals, and cabinet appointments. It's not correct that they eliminated the filibuster for Supreme Court nominations. That occurred in 2017. It was when the Republicans controlled the Senate to get Neil Gorsuch confirmed. I just wanted the facts to.
Dean Chemerinsky is correct. I'm sorry about that.
Okay.
And the second thing that I was going to say is it's a logical fallacy to say, because there are some parts of the system that are unrepresentative, like the Electoral College that comes to the Senate. Therefore, we have to accept everything that's non-representative. Therefore, the filibuster becomes permissible. I think we should eliminate the filibuster as it relates to our time of day and for everything else.
Okay. Here's another question. Hasn't SCOTUS simply become the third political branch of our government? Scalia and RBG, as far apart as they were philosophically, were confirmed with 90% plus votes in the Senate. Today, it would come down to a tiebreaker vote by the VP. So again, that gets to what does this proposal solve and what wouldn't it solve? If one big complaint that everyone seems to have about the court is that it's become more political, will this help address that? Is that even something that we should be worried about, or is that a distraction from more serious problems?
The Supreme Court's decisions have always been a product of the ideology of who's on the bench. Marbury versus Madison wouldn't have come out that way if John Marshall hadn't been Chief Justice. From the 1890s to 1936, the Supreme Court struck down over 200 federal, state, and local laws protecting workers and consumers, because it was a very conservative bench. The Warren Court handed down a series of liberal rulings because there was a liberal majority, especially in the later years of the Warren Court. And the current court is very conservative, and that's what produces its decisions. But I don't think that the court is more ideological now than it's been before, in the sense that it's always a product of who's on the court. The confirmation process is a separate issue. And I agree that in terms of whether or not we could implement term limits, we need to think about the confirmation process. I think the confirmation process is reflecting how deeply politically polarized our society is at this point in time.
John, any comments on that?
Well, I certainly agree with Erwin that the confirmation process is politicized heavily today. I would say that it's been politicized for a while, though. I don't think that's anything particularly new. With respect to Chief Justice Marshall, Chief Justice Marshall served for like 30 some years, I think, even all the way back then. And the fact of the matter is that Marbury versus Madison came out because John Adams created 6 new circuits, I think, and tried to stack the judiciary that way. The Midnight Judges, it was called, or the Midnight Judges Act. And President-elect Jefferson got pretty upset about it. So the politicization of the courts, unfortunately, has been going on for quite some time. I don't think that the fixed year term limits, as good as it may sound in theory, would actually fix any of that. Actually, I think it might make it worse, because now you have confirmations every 2 years. It's going to be just as nasty. I think the biggest problem is 2 things. The biggest problem is, number one, all those hearings are televised. You can thank Brian Lamb at C-SPAN for that. I'm not saying they shouldn't be. Okay, I think it's great that the public gets to see what's going on. But I also know that for a fact that whether it's lawyers or anybody else, especially politicians, when there's a camera there, they behave differently. That's just the bottom line. Number 2, I think the other problem is when judges, or especially Supreme Court justices, deviate from the plain text or the original intent of a constitutional provision or a statute, it looks like they're being political when they put in their own policy preferences. And Erwin's trying not to smirk or laugh because he knows this is the standard thing from us. But I'm sorry, it's just the way it is. When a judge or justice just puts in his or her own personal policy preferences. Nino used to have a little thing that said, dumb, meaning a dumb statute or a dumb idea, does not automatically mean unconstitutional. And I think that's right. It's not up to the Supreme Court to fix every little thing that's a dumb idea.
We should table the discussion about interpretation for our next debate in the
Sorry
series, which will be no, it was relevant. What you said was relevant.
The reason that I mentioned that is because that's one of the underlying reasons why we're even talking about age limits or fixed year terms or any of the other jazz. Good behavior is in fact cool. And the reason it is because of what we've discussed already.
I was going to say that our next debate is going to be about originalism. And so canons of interpretation will be an important part of the next program in this series. But Professor Chemerinsky, you look like you want to respond to something that John said.
The proposal for 18-year term limits isn't about getting a certain ideology on the court. It's giving every president an equal opportunity influence so that people can determine. The reality is that all decisions are a product of the ideology of who's on the court in important cases. When the Republican justices just overruled Roe versus Wade, that was their reading their conservative values into the Constitution. It was nothing but that.
Okay, I want to move on to an objection that's been raised about the 18-year proposal, which is that having regularized nominations every 2 years will destabilize doctrinal precedent. So there'll be too much changeover and therefore too much change in doctrine, and that will destabilize our legal regime and the stability that people have come to rely on. Professor Chemerinsky, how would you respond to that objection?
The current court gives so little weight to stare decisis already. I just mentioned what everyone knows, the overruling of Roe versus Wade, or this term, the overruling of the Lemon test, or in recent years, cases like Franchise Tax Board versus Hyatt that overruled a 40-year-old precedent, or Janus versus American Federation, or Nick versus Township of Scott. Given the current court's lack of regard for precedent, I don't think that this is going to more destabilize the law. Now, I would hope that justices, no matter how long they serve, would give more respect for precedent than the current court. But the real issue that this question raises is how much respect should there be for precedent? And the change in the composition of the court isn't the key for that.
John, do you have a response to that?
Yeah, I think there have been several studies in the literature about how it's very possible, perhaps likely, that with the fixed year terms, whether it's 18 or 7 or 21, that the justices, especially as their terms come to an end, are much less likely to coordinate with each other and are more likely to just do whatever they want, regardless of what the precedent may be. I think this is a valid concern. I don't know how heavy it is, but the other problem I think is that again, with the fixed year term, you're creating a problem when you don't, where none currently exists. And I think the confirmation battle would get worse. And with respect to precedents, I mean, I'm sorry, but it's important for justices to look at past cases, previous cases, and that's what they do, regardless of what their term is, whether it's for good behavior. We certainly laud and applaud Brown versus Board of Education. And I would say that the Justice Alito's opinion in the recent Dobbs case is not that much different than what Larry Tribe wrote back in 1973 or 74 in the Harvard Law Review. So I think that, but it's very hard to measure, and it's very hard to predict what a Supreme Court justice would do. And so, but I think it's a valid concern.
Okay, I'll move on to another audience question here. Professor Chemerinsky, you mentioned, I believe, that you believe that this could be done by statute, not by constitutional amendment, that a constitutional amendment wasn't necessary. Is that an accurate description of your view?
My preference would be to see it done by a constitutional amendment, but the argument has been made by Professor Kermit Roosevelt and others that when someone is confirmed for the Supreme Court, they're assured a lifetime position on the federal judiciary. It doesn't have to be on the Supreme Court itself. And so after 18 years, they could be shifted to being hearing cases on the Court of Appeals. And a number of constitutional law professors have taken that position.
Yeah, I disagree. I disagree with that. I mean, if you're going to do it, I think you'd have to do it by constitutional amendment. I mean, think about when we talk about judges of the Supreme Court, ambassadors, cabinet ministers, and other officers. Well, I mean, why not make the justice an ambassador? Why put him on the inferior court? Why not make him a cabinet minister? I mean, I think it's insane. The other thing is, what happens if when the Chief Justice's term comes up, 2 years? What do we do then? Do we appoint another Chief Justice? Do we elevate an associate, or do we take one of the so-called senior justices and stick him or her in the chief's position? whether it's for the remainder of the term or a new term. I'm just saying, if once you confirm a person, that person is in that position. I mean, as it is now, for example, if a district court judge gets nominated to the appellate court or even the Supreme Court, he has to go through a separate confirmation process again. So I think it's a real problem. I understand the arguments. I'm just saying I strongly disagree with them. And I think if you're going to do it by constitutional amendment, but be very clear.
Professor, you look like you wanted to respond to that.
The Constitution is ambiguous on this. It doesn't say. And so long as you protect the life tenure of the individual, I think that's sufficient. In terms of the Chief Justice, the tradition since the beginning of the Constitution is that the Chief Justice is a particular appointment. So when William Rehnquist passed away, a new Chief Justice was appointed there. So I would say after the Chief Justice serves 18 years, somebody else is appointed to be Chief Justice in that role. I don't see that as a practical problem.
Okay, I wanted to raise another objection that people have brought up to this proposal, and that is that it might introduce the possibility of conflicts of interest, much like revolving door provisions try to address with members of the legislature, for example, about what kind of employment they might have after their public service. So it's been suggested that Supreme Court justices might have incentives to cater to certain companies, institutions, types of institutions, in order to increase their chances of favorable employment after their tenure. How would you respond to that, Professor Chemerinsky?
It's interesting. We accept fixed terms for all other government officials, even though there's that risk. I actually think that something else would happen that would lessen that risk. I think if it was 18-year non-renewable terms, presidents would tend to pick people a bit later in their career, so it was more of a capstone. Instead of picking someone at 43 years old who would then be done at 61, I think it's much more likely they'd be willing to pick people in their late 50s and 60s to serve the 18-year term. And I actually believe there's something good and desirable about that, because I do believe that more experience in law, in life, is a benefit. And so if a president was picking somebody, say, who's age 60, who'll serve till age 78, I don't think they're going to be worrying about how might they profit from being a Supreme Court justice.
John?
Well, I would respond with three points. I think first, with respect to the compensation clause of it, I think although the proposals differ, focusing only on what Erwin said today, his proposal was that the senior justice would still continue to collect his or her salary for the remainder of his life, is my guess. That's number one. So that would kind of ameliorate or mitigate the do I need to find a job problem. Number two, I think with respect, now Erwin brought up being nominated a little later in life. I suppose that's possible, but it's possible now. President Clinton nominated Ruth Bader Ginsburg, and she was 60 years old. And she served a very long and admirable career, both when President Carter nominated her to the DC Circuit and then on the Supreme Court. And so I think that's neither here nor there. Second, Erwin did mention the possibility of physical health problems or mental health problems, what some people call decrepitude. But now he's also saying that presidents will nominate people who are older. Well, I mean, you gotta pick one or the other, but you don't have to. You know why you don't have to? Because you can just stick with the system of the way it is and let the presidents and the Senate decide whether somebody is qualified, whether it's physically or educationally or whatever, for the high court or any other federal, or any other Article 3 court, I should say.
One of the problems that this proposal is supposed to address is, as Professor Chemerinsky mentioned in his comments, that right now there's an incentive for justices to retire when a president of their party or that matches their ideology is in office. It's been suggested that this will address that, but what do you do about, say, a justice who still decides to retire before their 18-year term is up, while a president that they view more favorably is in office?
There's an easy answer to that. The person who's appointed to replace that individual fills out the unfilled part of the term. So if somebody served 15 years and then dies in office or retires, the person will be appointed for the remainder of the term, the 3 years that's left. It wouldn't be a situation where they would be able to step down and then ensure that the president of their party gets to replace them.
Which would then aggravate the problem of which I think both Erwin and I agree, a heavily politicized, nasty confirmation process, because you'd have more of them more frequently. That's number one. And then number two, I think you have so either way, whether you have fixed terms or not, somebody can decide to retire based on the president that's in office or the president or Senate combination, that's there. Listen, a lot of people were, I think, wrongly pressuring Justice Ginsburg to retire when President Obama was in office, and the same with Justice Breyer. People were sending signs to his house saying, "Time for Breyer to retire." That's not cool. That's not right, and that's what life tenure avoids.
We have a question. Go ahead.
We've talked a lot about the confirmation process. We all agree that the confirmation process has become deeply politicized. I don't think that this proposal would make that worse. I think there's a way it would make it better. That I think if both sides knew that every president was going to pick every 2 years, I think they would work out an accommodation because both sides would benefit from that. Too much now depends on the accident history and each side trying to capitalize on it, such as how the Republicans blocked Merrick Garland and rushed through Amy Coney Barrett.
Yeah, I think Erwin puts a lot more stock or gives a lot more credit to politicians and especially senators than I do. So we'll just leave it at that.
Okay, we have another question from the audience. This may be our last one. How do you think that the 18-year proposal will impact public trust and confidence in the judicial branch? It's an essential question for our time.
I think whether you're liberal or conservative, you have to acknowledge that the public esteem in the Supreme Court is the lowest that it's been. Now, John wanted to put the blame for that on the Democrats. In fact, I'd put the blame on the conservative justices who are so out of touch with the majority of people. I mean, the reality is our country is more politically polarized than it's been since the Civil War. And what does it mean that the Supreme Court has come down so solidly on one side and so far to the right on that political divide? My hope is that by having a meaningful reform, 18-year non-renewable terms, we have a way of restoring public confidence in the court.
Yeah, I think focusing on just how the proposal itself will adversely affect public trust and confidence, I think it might. I think there's a reasonable likelihood that it will, especially because it depends on how the constitutional amendment or statute, regardless of how the text is written or how it's phrased. So I do think, much like court packing, I think something like this would be seen as a nakedly political move. Again, I understand Erwin's point that it's not political, bipartisan, et cetera, et cetera. I get all that, but I'm talking about public perception here as the question asked. And I think it's anytime you're changing a constitution or if changing a constitutional structure, even if by statute, that's a reasonable concern. And then with respect to, loss of confidence in the courts, I mean, when you have the president and all of his people talking about the Supreme Court and how terrible it is and how mistaken it is, and you've got a lot of people on that same side talking about burning down the Supreme Court or abolishing the Supreme Court, hey, that's definitely gonna, especially gets magnified on MSNBC.
Okay, well, I think that brings us to the end of our program. I want to thank Erwin Chemerinsky and John Shu for joining us and taking time out of their very busy schedules to be with us. And I want to thank the American Bar Association and all of the organizations that made this program possible. I want to thank everybody who took their time out on a summer Friday afternoon to attend. I'd like to remind people to complete the survey that will appear on your screen when the program is closed. And if you're in Illinois and you want CLE credit, if you're an Illinois attorney who wants CLE credit, look for an email from us on Monday. And we hope that you'll watch for our next program, which is going to be the second debate in the Civil Disagreements series, and that will be about originalism. So another timely and important topic. So thanks again to everyone. We hope we've given you a lot to think about. Please, investigate all of our organizations and see if there's anything that you can learn. And we'll see you next time. Thank you so much.